On yesterday's programme, we heard from voices supporting and opposing South Africa bringing this case against Israel. What we wanted to explore today was how significant this could be for the power and reach of this thing that we often talk about, but talk about rather hazily, international law. Antonios Tsanakopoulos is Professor of Public International Law at Oxford University. He's here in the Newshour studio. Antonios, if I can start with this specific case before we move on to the broader issue, when can we expect an interim ruling? And remind us who is doing the ruling.
So we should expect the ruling probably before the 6th of February, when the bench of the International Court of Justice changes. So this should be really quick. In fact, this is a very quick procedure. But perhaps we can say a few things about the court so that everybody understands what we're talking about here. And this being the International Court of Justice in The Hague, this is the principal judicial organ of the United Nations. So you can say it's, let's say, the UN's top court or the world's top court. It's made of 15 judges plus ad hoc judges on occasion where states before it don't have a judge on the bench. So it's currently made up of 17 judges for this case, and it can issue a provisional measures order, which is this urgent order. And the idea behind that is, like in domestic law, to preserve the subject matter of the case or to make sure that there is no irreparable harm while the court is hearing the case. Because as you correctly said, Tim, this is just the opening salvo in what will be a very long case if it continues. It could take years.
Right, okay. But the very fact that they might issue an interim ruling, which could, were they to tell Israel to cease fire and Israel to abide by that ruling, could have a real impact on the big events happening right now. We often talk about international law as an important set of principles, but sometimes it seems sort of rather toothless. Given that, how significant do you think this could be?
So I think it is very, very significant. You're absolutely right that international law is difficult to grasp, sometimes also for the students. And in general, all of us are sort of socialized into domestic law. And we tend to look at the subjects of the law as individuals who can suffer punishment, who can be made to do things and so on and so forth. But if you think of the state, which in reality doesn't exist, it's just a legal person created in your head by the law as an actor. It's very difficult to understand enforcement against states in the same way. Now, obviously, nobody can sort of like grab Israel and shake them around or do anything to the UK in those terms that we have in our mind, sort of from criminal law mainly. But what you can do is hold states responsible and also order them, impose binding obligations on them. So the Provisional Measures Order of the International Court of Justice is actually a binding order, which means that if the state that is ordered to do something does not comply, then it definitely is breaching international law. It will be held responsible for this, which means a number of things. It means that it will have to undo any harm. It will have to give compensation for any damage that follows from the breach and so on and so forth. The most important impact of decisions like this is that they mount the pressure on the recipient. So you've already seen that South Africa starting the case alone is already having some impact on the ground before the court even says a word.
But you're suggesting that enforcement comes principally through a sort of political pressure.
In general, the only way that you can force legal entities to do anything is basically by them eventually acquiescing to pressure and complying with the law.
And I guess the very fact that Israel is participating in this would suggest that that is understood.
It suggests that they take this really, really seriously and that they are there to make their position heard.
What do you make of the fact that it is just about the most serious charge that there could be, that it is genocide?
So this is slightly problematic in a couple of ways. This is because states cannot be brought before the International Court of Justice unless they actually agree. And the ways that they agree are quite complicated, and we don't have time to go through them now. But in this case, what South Africa has done is to find a treaty, the Genocide Convention of 1948, where both states have agreed that if there's any dispute as to the implementation or application of the treaty, they will go to court. And so South Africa used this to bring Israel before the court, which means it has to present an argument that this is a violation of the Genocide Convention, if that makes sense.
Professor Antonios Tsanakopoulos, Professor of Public International Law at Oxford. Thank you so much for coming in.